Hi, I'm Ryan McLeod. I'm a partner in the litigation group at Wachtell, Lipton, Rosen Katz in New York. I came to law school not knowing anything about clerkships, but learned about clerkships from Professor Beal, who was my crim law professor my first year at the school. She essentially told us clerkships are something you should think about doing if you want to litigate. They're great. They're all over the place. Go get one. And I didn't really know much about that, but thought it was something I should look into doing because I did know I wanted to be a litigator. I was interested in a chancery clerkship specifically because I knew by that point I wanted to practice Delaware corporate law. I found it a little bit randomly during my 1L summer doing bankruptcy, which pivoted somehow into liking equity. And the Court of Chancery is one of the only courts of true equity that still exists in the United States. So while I spent my second summer in Delaware, the folks I was working with there told me you should clerk for Chancery. And it seemed like a good fit. I loved the work I was doing. It was a smaller court. It was an earlier process than the federal clerkship process, which even then was sort of a mess. And so I applied to both the Delaware Supreme Court and all the then 5 chancellors on the Court of Chancery and was really lucky to get one. You do a lot of reading, a lot of writing, a good amount of research. But maybe the best part of the work is really just interacting with your judge, because I think the truly greatest takeaway from a clerkship is the mentorship relationship you get. And I couldn't value something more than I value my relationship with Chancellor Chandler. I still harass him every other week or so with some random question. I'm sure he's sick of my phone calls, but he's still kind enough to take them. We had a busted deal litigation. There was a merger that had been proposed under which a company called United Rentals, which you probably see all over campus because they rent construction equipment, was supposed to be sold to a private equity firm. And it was right at the height of the financial crisis, or right at the beginning of the financial crisis. The private equity firm wanted out of the deal. There was a lawsuit in Delaware for specific performance of the merger agreement. It was an extraordinarily expedited trial. The case was filed, I think, at Thanksgiving. We issued a decision before Christmas. And we had to write the decision essentially over 40 hours. And so my co-clerk and I, who's the best co-clerk in the world, Marjorie Duffy, I love her, knew we were going to have an all-nighter. And we were in chambers, holed up, working on this. And we couldn't get the judge to leave. We wanted him to go home so he would rest. We basically had to throw him out of the office. And he told us at, 10 or 11 at night when we finally convinced him to go home, that if we were going to be there all night, we had to go outside just before midnight and reset the alarm in the courthouse, which turned out to be a very complicated process, way harder than working on the opinion. We managed to do it, and we managed to go to the supermarket to get some food for the staff potluck holiday party the next day too. Writing. You write a lot as a law clerk. You read a lot of writing as a law clerk. You see a lot of editing as a law clerk. You read good briefs. You read great briefs. You read terrible briefs. You write good drafts and bad drafts, and your judge finds some alchemistic way of making them actually good. And that process is probably the most valuable thing you get. A second thing, not to be facetious with all the writing, but is probably just seeing good judgment in action. Chancellor Chandler had the best judgment of anyone I've ever met in my life, and just watching him make decisions and think through things has informed the way I do it. When I approach a case, I try to think about where it ends, because every case has to be prepared from the very beginning, from before you write a complaint or before you write a motion to dismiss, with a view in mind of what your closing argument will be or your post-trial argument will be. And so if you're not mapping out to the very end and understanding what the arc of the whole litigation is, both narratively, doctrinally, factually, et cetera, you're doing it wrong. And so the thing I got from seeing the back end, the final product, the trials that we saw as a law clerk, was understanding I need to land that plane here. What's my flight path? What sort of equipment do I need? How am I going to get there? You should take the clerkship. It's a no-brainer as far as I'm concerned. There's a lot of debt everyone gets in law school. It's expensive. You want to go make a salary. You want to get out of school, start living your life, being a real person. But your career is really long. The arc of your practice will last years and years and years. And that 1 year could not only change the trajectory of it, but make every subsequent year richer, more valuable, better, and the relationships you'll form from it are relationships you'll carry with you no matter where you go thereafter.